that are overlapping before the tribunal. And there is also a question of fairness. What we're telling all parties concerned here today, who are all very sophisticated lawyers, is let's set this aside. Let's sit down at the table together. Let's do what Justice Favel told us to do, which is to initiate discussions. And let's come back to a solution that is fair to all. That means two things: a compensation formula that does not re-traumatize the people in question, because it's not just a question of money. And another aspect, both with very important compensation aspects and long-term investments, to finally put an end to this system that is prejudicial to Indigenous children. 50% of children today who are in the family care services and who are only make up 7% of the general population. That is not fair. And that's what we're going to do with the concerned parties. So people will say that since the beginning we're more concerned with money. That is not the case at all. The order to pay, and if people are challenging that fact, it's because they didn't read the decision. It came out this year. It didn't come out in 2007 or 2016. It came out this year. We accelerated the process to align with the federal court's decision. At the federal government, what we did is accelerate the process to bring an end to it all. There is a jurisdictional aspect that we continue to challenge, but that does not prevent us from moving forward in the spirit of reconciliation with a financial offer that will remain confidential, obviously. And you should know that the other parties have agreed to this, to this negotiation. So we're not going to take opposite positions before a court next week. We're going to talk amongst ourselves and resolve this conflict for once and forever. Question: how can a child that is traumatized, who spent a few weeks, who was traumatized for a few weeks, would be different than from a child who was traumatized for a few months? Are you saying that one child's suffering is worth more than another or less than another's? Answer: look, Louis, these are very painful subjects for the children in question. Those who are living with the repercussions of being traumatized. Obviously, someone who was unjustifiably removed from their family following discriminatory practices has been harmed. We know from all the studies that were done that traumatizing children during this prolonged period of care. Some children were beaten, some children were sexually assaulted. This behavior is abhorrent, and of course, money cannot fix these harms, these long-term harms. But we're talking about reforming the system. It takes a great deal of conversation, discussion, and this is what we want to do. And we've been, since we formed government in 2015, we've been trying to resolve these issues once and for all. And these things cannot be resolved overnight when faced with a court decision. Some of these cases go back to 20 years.
First, David, it's hard to quantify in monetary terms the lifelong prejudice that a child can suffer, an Indigenous child, from being removed from their family, from their culture, from their language. But that's the imperfect system we're facing, and trying to fix the harm that children have felt, and to the extent that money can compensate for it. The court found that the discrimination occurred and that the act of removal itself was subject to monetary compensation. We know that children that have spent a long time in care, whether it's 2 months, 2 years, 20 years, the more you're in care, the more risk you are at suffering physical, mental harm, including rape and beatings, moving from family to family, and the trauma that's related to that. There are children that are entitled to more than $40,000, and that's clear. This is something that it's probably hard for people to hear, but that's the reality of it. And those are why these discussions are so difficult. It's why they're so important in getting to a financial package that is fair and equitable, and then fixing the system that's broken, with 50% of Indigenous children in care only representing 7% of the population. It's something that that we need to fix, and it's something our government has said we're going to fix. But we need the expertise of Dr. Blackstock. We need the expertise of the Assembly of First Nations, and we need to apply the reports that have been produced to us as to how to fix the system. And we know that it will cost a very large amount of money to get there. Minister Haidu probably would like to add on that as well.
Well, I think, Mark, you've really summarized it well. I do think thanks are due to Dr. Blackstock, of course, all of the parties. But, I had the opportunity to speak with Dr. Blackstock for the first time after being appointed. And it's obvious that she has come to this work from a very personal place, a lot of personal experience in her previous work, and obviously with her heart focused on stopping the harm. Compensation, of course, and the Government of Canada, as I said in my remarks, does not in any way quibble with the need to compensate, but also equally to make sure that this doesn't happen every day in an ongoing way to First Nations children around this country. I think Mark has been very eloquent in talking about, the extent of the harms. I personally have worked previous to politics with and amongst Indigenous people who went through a particularly brutal process to receive reparations from residential school harms that was extremely invasive, re-traumatizing, and in no way would I want to be a party to a process that in any way re-victimizes people. So that will be part of the work of the global settlement, to understand and to put into place a program and a process that quickly gets resolution for people, but in a way that is compassionate and is respectful.
Next question before we turn to the phones.
Yeah, hi, Mr. Miller. Mackenzie Gray with CTV. You mentioned Cindy Blackstock. We were talking with her earlier, and one of the things she said throughout this whole case is that one thing she believes your government might be trying to do is pay some people who had, an easier ride per se, less money than $40,000, and some people more than $40,000. I've asked the Prime Minister, and you've been asked again. So can you just clearly state whether or not the floor for compensation is $40,000?
Mackenzie, as we've said before, we have put forward a significant financial package to fix the harm caused to Indigenous children, to First Nations children that have suffered at the hands of the healthcare system, at the Child and Family Service system, and its discriminatory impact on them. We have also put a significant financial package on the table to address long-term reform, so that we're not back here in a couple of years going through the same exercise, and children are traumatized by being removed from their homes. That is an important step for which we absolutely need Dr. Blackstock at the table. I understand her hesitation. If I were in her position, and I don't think I ever could put myself in what she's gone through, the Canadian government spied on her, and that is something that would not inspire confidence in people like me sitting here today. But she has graciously opened her heart because she's fighting for First Nations children. And she will be at the table informing our decisions on long-term reform. So we fix this system. And that's key. The financial package is significant. I'm not going to go in detail for it because we need to be able to have a serious discussion about what the floor is, what the ceiling is for those who have suffered the most harm, and how that parses out between people that wouldn't necessarily be covered by the CHRT order, whether it's the $40,000 maximum or years that aren't comprised by the order. So there are issues of equity and fairness. There's no simple answer to the why don't you just pay it out argument, but people need to realize, and it's very important, that there are parties that would not be compensated fairly if we were simply to implement the orders in the way that they have been issued. There would be significant issues with other classes, as well as long-term reform, which is absolutely key to this discussion.
So it's up for discussion on the floor.
And if maybe I can jump in as well, Mackenzie, and it's nice to hear your voice. I'll say that the intent of the government is to make sure that people are fairly compensated. Dr. Blackstock knows that we share that interest, and I know that trust takes time to grow, but just the fact that we have all parties agreeing to pause this the appeal and to sit down together, starting immediately to find a global solution, should indicate to you that there is a serious commitment, financial commitment, on behalf of the Government of Canada to hopefully begin that process of rebuilding trust with the parties that have fought for and on behalf of First Nations people for a very long time.
So discussions will be ongoing about the floor, but I want to ask about the timing of this. This litigation's been going on for a while, and subsequently you lost the appeal a month ago. It's 6 o'clock or just 6:15 on a Friday. Why did you wait till the absolute last second to announce that you've come to an agreement, despite the fact that you're still appealing the case?
Oh, look, the discussions, it's no secret to anyone that putting together a financial package like that and looking at the best way to move forward is something that does take time. And it's something that we have been working with the parties over the last few days to do. And it's something that involves serious discussions, some backwards and forward discussions that I won't share with you. But it isn't slow playing things. And I think, one of the narratives that we've seen is this has been a slow play. It hasn't been at all. The order to pay came down this year. We moved expeditiously to appeal the issues that we had deep concerns with. The order was issued by the tribunal, and during the last 30 days, a good chunk of which was during caretaker, as the new cabinet is being formed. That does take some work to get going and to have concerted discussions with cabinet and the prime minister in moving forward in a way where we are compensating and putting forward a package that makes sense in the spirit of what the judge at the federal court has said, which is getting our heads together and talking about it and working on what is key to this and was not included in the order, which is working on long-term reform.
Wonderful. We'll now just turn to the phones. Operator.
Thank you. Merci. Please press *1 at this time if you have a question. Veuillez s'il vous plaît appuyer sur étoile 1 maintenant pour poser une question. Our first question is from Christy Kirkup from the Globe and Mail. Please go ahead.
Hi, good evening, ministers. In precise terms, what do you think can be achieved in talks between now and December with the parties that is substantially different than what the tribunal ordered and what the federal court upheld in terms of compensation?
Maybe I can start and turn to Mark. First of all, let me just say how grateful I am to have been able to talk to so many of the parties over the last 5 days to get to this place. Maybe it's 4 days, it's all a blur. And the willingness of the parties to, of course, with that significant offer, come back to the table with one sole focus, which is doing right by First Nations children. And of course, those people that have been harmed. That willingness means that complying with the court orders will result in a process that has been informed and indeed collaborated on with Indigenous people and with their representatives, so that the Government of Canada has a roadmap on how this should proceed, as I said, in a way that A, is respectful and not re-traumatizing, but also gets to those longer term reforms that Minister Miller has worked on and talked about for quite some time. That piece is equally important, and that piece is equally tricky, if not more, in my mind, because that's about ensuring that this doesn't happen again and again to any First Nations child, and that First Nations children, regardless of where they live, have the absolute best and equal opportunity to thrive. So maybe I can turn to you, Minister Miller, to talk a little bit more from your previous experience.
Yeah, well, anything that gets us to a position where we can drop the appeal is a very, very good discussion. But we can't do that without that significant financial investment to repair the harm that's been caused, and a significant financial investment to deal with long-term reform. And that can only be done by having talks. There are many parties to this. This has the potential to be messy, but messy is good. That's where we figure things out and come to one mind as to how to move forward and what classes deserve what level of compensation. And that's not something that the federal government of Canada can decide alone. If it were a different scenario, or perhaps under a different government, you would take adversarial positions and you would spend the next 30 days or whatever the appeal period is to file motions doing lawyer against lawyer. And now we are committing and continue to commit resources from Indigenous Services Canada so we can sit down with Dr. Blackstock, with Council to Mishoom and the Assembly of First Nations and others to come to a solution which is based on the best interests of the parties involved, and that is getting quick, expeditious payment and a process by which that is done that does not re-traumatize people. And key to this, the long-term reform package, which Dr. Blackstock has been advocating for so long. So this is an opportunity for a fresh start. I do not want to presume the outcome of this, Christy, because it is so key to allow us to have that space, and putting the appeal on pause allows us to focus efforts not on taking adversarial positions, but rather to be talking to each other about where we can find some commonality. And if we can drop the appeal altogether, that would be great. If we can winnow it down to the elements that perhaps we have some remaining disagreement on, well, that means that people that we don't have any disagreement with about their compensation levels and package, including those that may get over 40,000, we can move quickly and expeditiously on making sure they get compensation. Oui, j'essaie de souvenir ce que
I'll try to remember what I said in English. What we hope is to be able to sit down and rather than take up adversarial positions in a judicial system which is black and white, and come up to a practical and fair solution to compensate the children who suffered this prejudice and the other people that were affected too. We would like to achieve long-term reform of the system, which remains broken. Rather than spending our time preparing legal briefs and developing positions, our efforts will be focused on consultation with the staff of Indigenous Services Canada and all other concerned parties to arrive at a practical solution, really reduce areas of disagreement, perhaps drop the appeal, or in the worst case, have an appeal that is very limited to the areas in which we remain in disagreement. But I don't want to presume the outcome of all these discussions today. We still have to have those discussions. And we do have a fairly limited time period in which to do so.
Differently, Kirsty, we're here putting the appeal on ice, so putting it in abeyance precisely because we think we can arrive at a solution that's comprehensive and global, that includes not only what the CHRT was trying to do, but also touches the 2 and now 3 class actions, as well as putting the long-term reform in place. We're here because we think we can do that in a short period of time. We've got the goodwill of the parties. We've put a significant amount on the table to get the parties to the table, and we're confident that this can happen. If we just try to implement the CHRT decision through the framework agreement, that would we think that would actually take longer at the end of the day, and there would still be litigation or disagreements over that. So we're putting everything on the negotiations in the room, which obviously we're going to keep confidential, and we're pretty confident that we can do that.
Christy, do you have a follow-up?
Yes, I do. So just to confirm then, the parties in the separate class actions are also going to be involved in these talks, and in theory, you're looking at what you describe as a significant financial settlement that would essentially resolve the CHRT case and the class actions all in one foul swoop?
That was the intention of the offer, Christy. Yes, absolutely.
Operator, next question.
Thank you. Merci. The next question is from Dylan Robertson from Winnipeg Free Press. Please go ahead.
Hi, thanks for taking our questions, ministers. The Prime Minister said this month that the government was consulting groups about this case. Just a week ago, Ms. Blackstock said that she had no clue who that included. So could you please specify who outside of the parties to the case your government was consulting with, and when did that outside consultation start?
Yeah, thanks, Dylan. I simply think this was a reference to the mediation process. We certainly have been in talks with the parties over the last week or so. They've been very intense, but the Prime Minister, I believe, was simply referring to the mediation process.
Dylan, do you have a follow-up?
Right, okay. That doesn't quite explain Ms. Blackstock's comments, but I'll follow up here. I'm wondering how confident you are that you can actually sort out the question around the scope of the tribunal in 2 months, just given how long this has gone on. I mean, surely even during the caretaker period, this could have been advanced by government lawyers.
Well, maybe I can start and then turn to Minister Miller. That's okay. It's hard to see, Mark, whether or not you're reaching for your microphone. I think my conversations, and I'm new to this team, as you know, and new to these conversations in some of the parties, not all of them, because I do come from Northern Ontario. And of course, I do know Grand Chief Archibald from previous work. But I will say that the conversations I had with the parties this week indicated to me that everybody is extremely serious and extremely, I would say, cautiously optimistic about the ability to find a path forward, especially with the seriousness of the government's significant offer. This is no doubt going to be a very intensive piece of work, but there are, I think, no qualms by any of the parties that it needs to be done as quickly as possible for Indigenous, for First Nations children, and for the people that are survivors of the discrimination and systemic racism. So my sense is that all parties, including the Government of Canada, are extremely committed to doing everything it takes, as I said earlier, to reach that global resolution. And I anticipate that after years of hard work, another couple of months of extremely hard work doesn't daunt anybody.
And Dylan, simply, during the caretaker period, even leading up to the elections, there were talks that were ongoing. They did not lead to the conclusion that we had hoped, but we are in a much better position today, particularly in light of being able to look at a global offer as well as long-term reform.
Operator, next question.
Thank you. Merci. Our next question is from Ian Kaufman from Dougal Media. Please go ahead.
Hi, yeah, thanks for taking my question. My question is for Minister Hajdu, and she talked about the process of rebuilding trust with First Nations and Indigenous communities. I don't think anybody could argue that filing this notice of appeal has set that process back, regardless of the intentions. And I just want to ask her if she truly believes that damage to the relationships is worth it to continue this appeal.
Well, thanks, Ian. And it's also nice to hear your voice from my own hometown. I'll just say what gives me comfort is that this is an agreed upon approach by all the parties. There has to be trust in order to agree to this approach. And even though it is fledgling, I will say that it's positive. As I mentioned, I have spoken to the parties, and I have a deep respect for the work that they have been doing. But there is an optimism that the government is extremely serious about ending discrimination and compensating people who have been harmed. And there is an eagerness to get started. So I will say that this is a very, very important piece of that rebuilding of trust. And I am, again, grateful to the parties for coming to this table of negotiation with us. And I look forward to what we can achieve together.
Thank you. Do you have a follow-up?
Yeah, for Minister Miller, I believe at the beginning of this presser, I heard him say that there's no intention to reduce any amount paid from the order amount, and I'm just wondering if he can confirm that, or if perhaps I misheard or he misspoke.
No, we need to let this process occur between the parties involved. I simply said, and I believe it to be true, that there is no intention to reduce the amounts to be paid to the children that have been removed from their families. And in fact, increased it above 40,000 in some cases.
We'll now turn back to the room for questions. Go ahead.
So, hi there. Yeah, it's Fraser from APTN National News. So maybe I'm just missing something here, but I think that Canadian Human Rights Tribunal decision is actually fairly clear. It sets some parameters, and it has a group of children that are covered in their families, and it's pretty clear in the parameters. So that there's nothing there that's stopping you from working on the child welfare system as a whole that needs a lot of restructuring, obviously, and you know that, and you could be working on that today, tomorrow, or you could have been working on it since you got elected. I'm sure officials have been. It's a complex thing. So those are two separate issues, I think. And the other thing is, I guess you are calling this it's an appeal. It's not a soft appeal, and you're saying you don't want to be adversarial, but you've now gone to court twice. That's adversarial. There's no, you're lawyers, you know that there isn't degrees of adversarial, so you obviously are doing that. So, why don't, and I mean, Minister, to be quite frank, you referenced another government. Yes, you're right. They would, if it was a Conservative government, they would put out a number that they thought was reasonable, and they would probably, but what you're doing is you're appealing. You're not saying why you're appealing. You're saying you're not giving. You say you don't think the Canadian Human Rights Tribunal should have jurisdiction, but you won't say who should. Surely not you. I mean, you have a bias. You're not the ultimate arbiter of all this, and so. And we're here at 6 o'clock, or even 6:30 now on a Friday night. Surely you weren't negotiating, this morning. It's a calculated move, obviously, to bury this in the news cycle. So how do you expect anyone to take you seriously on this, honestly?
Well, maybe I can start and then turn to Mark. There are a lot of assumptions in that question. Indeed, we have been negotiating and talking to the parties up till and including today. Trust does take time to build. This is an appeal with a pause on any litigation to allow that space and time for the parties who have agreed, by the way, all of them, to come to the table to find a way forward, to respect the ruling of the CHRT, but to do it properly in a way that gets money to people who need to be financially compensated, does so in a way that is trauma-informed and respectful of the ideas of the litigants and the parties, if you will, who are experts at designing these kinds of systems, and importantly, how that system of reform should unfold. I think this is really, really important, that this is all of the parties sitting together, all of the parties agreeing to a stay of the appeal, all of the parties agreeing to begin those talks Monday morning, and to work extremely hard to get this work done for First Nations children.
Yeah, look, I obviously by your question, there won't be much convincing you, but I'm sure you'll do a great job in making sure this doesn't get buried, and I'm sure David behind you won't either, and Christy, who asked the question, and Mackenzie and Stephanie, you've done excellent jobs in doing in covering this issue. It is one of national interest, and we're sitting in the National Press Theatre in front of all Canadians and Indigenous peoples to discuss this. It is not accurate to say that there was nothing going on this morning. I know it. You can see the bags under my eyes. These were negotiations up to the last minute and discussions up to the last minute. We need these parties at the table to move forward on long-term reform. Like you said, this isn't the federal government deciding. And admittedly, throughout all this, you've seen that there's very little under our control. We're here with open hearts, open hands, and saying, work with us to work on long-term reform. We've tried to do long-term reform or even reform on our own. It's failed. We're doing it with parties involved, with the IFSD studies to support it, and we're prepared to move forward with a significant financial package to back that up. And frankly, for any government that would purport to replace us, make this irreversible, because this is about the future of our country. Indigenous peoples know it well, and people like me, or that have even a that are looking at this and are tuning into this. This is about being able to look at your own children in the morning. It's about being able to look in the mirror. So it's very important who we are as a government, but it's also very important to who we are as a country, and we're very serious about this. We're very serious about sitting down. And yes, we did reference a previous government, but frankly, everyone's to blame. And we need to be able to be mature enough to say that and say we're putting this on pause. We do have challenges with the CHRT order. We could implement it tomorrow, and we wouldn't fix long-term reform. We wouldn't compensate those who are the most egregiously hurt by this. We want to work with the councils in question to come up with a comprehensive way to compensate the same children that are being covered by 3 or 4 sets of legal counsel. That is not unproblematic, and at least you do need to recognize that. I get the point, and we're very emphatic about moving forward with the parties, and that's why we put something in front. I won't presume the outcome, because I think it's very important for us to have those discussions in a situation where we're not actually drafting legal arguments to oppose each other. And I'd get people who are frustrated with the appeal. I am too, David is too, and so is Patty. It isn't the position that we want to be in, and certainly it doesn't help with reconciliation. But we're doing something that we think is right. It'll be an equitable and fair way to address this, but it isn't decided solely by the federal government. That's why we're sitting down and going to have those discussions over the next 2 months.
Yeah, well, thanks for that. And I don't feel like to defend my organization, but I work at we talk to Indigenous people all the time, and these assumptions are based on what people have been telling us long before I was there for years. Not just your government, the previous government, that's true, that governments have a fixed set of rules. They say they don't want to litigate, but in the end they end up in courts, and they're adversarial, right? So I get this issue has been going on for long before your government was around. It sadly will probably be going on long after your government isn't around. It's a very complex issue. So I guess with this ruling, it came down, you decided to take it to court, not the other party, your government, and then you decided to appeal it. And now, so what motivation would the parties, they've already been fighting this long before you're around, and they don't really have a lot of trust in any government. What would be their motivation to settle this when they basically got a judgment that clearly agreed with the Human Rights Tribunal decision, and you clearly don't agree with it, but you won't say exactly why. You say you won't give numbers. You'll say it might be more, it might be less, or so it. You're talking about long-term reform. So I guess why would you think that the parties would be motivated to settle this when it's just another government fighting them in courts? And they're doing pretty well on the decision right now. So why would they be motivated to settle it out of court?
Because they have an opportunity to make a difference and be at the table on long-term reform. And I don't blame them for not trusting us. I don't blame them one bit. But they're there. We've opened up the ability. We're saying to them, we're not deciding from on high anymore. We'll sit down. There's a significant package on the table, and frankly, it's something for the time being. And I get that people are entitled to answers, but we need to keep out of the public eye in respect of the parties in question.
And I'll just say, I'll add to that and just say that it's been very clear in my conversations and work in the short time that I've been now the Indigenous Services Minister, that there is a sole motivation. And the sole motivation is to do right by Indigenous children and people who've been harmed by this system. And I think what I got a sense from the parties as we worked through this last very hectic and very busy days for all the parties was a deep desire to get that work done and a beginning of a hopefulness that they're working with a government that understands that solutions have to be designed by and with First Nations people, and that they have an opportunity to work with a government that deeply understands that and has put forward a significant package to be able to achieve those goals.
Wonderful. Next question.
Hi, Ministers. David Thornton, CBC News. Obviously, there's a gulf between you and the other parties involved. Otherwise, Cindy Blackstock would be on the stage with you. So can you tell us how far apart you all are in negotiations?
No, not really. I think we need to have that discussion in private. Certainly, we've bridged a gap over the last little while by making that offer. Otherwise, we wouldn't be in a situation where we're, I don't like the imagery, but and I despise the imagery, but we're putting our swords down. And that's something I believe we recognize by AFN and Dr. Blackstock. I don't want to put words in their mouth, but the trust is thin. We know that, but they are willing to extend it for a certain period of time and work with us on fixing the system. And you know, it was mentioned in the previous question that the CHRT order can be implemented, but it does touch on long-term reform, on major capital, and we want to work with the parties on that. We need major investments into communities to make sure that again, the system that's being underinvested in is fixed. And we need their work, we need their advocacy, and we frankly need them to hold us to account. Again, I can't guarantee success on this, but I can guarantee you we'll do our utmost, and we're willing to fail trying, and that is the reality of it. I don't want, again, none of us on the stage or Minister Hyde want to be in an appeal position. So we're going to work like hell during the next 60 days. Patty?
I'm just curious, like, it sounds like you're trying to do a lot of things here. But why not just comply with that ruling, compensate these children, and then figure out how to do all the other things that you want to do, and the people that are left out, address that as well. But you can do something today. Why not just get it done and then figure out how to do all the other stuff you need to do?
Mr. Heidi, do you want to?
Well, thank you. Well, thanks, David. And I'll say this, and I've answered this already, but I'll answer it again because I think it's so important. We want to work with the parties to make sure that we get to the end goal, which is to compensate people who have been harmed and to create a better system, equitable system, a compassionate system, so that no more harm is done. And I will say that the government of Canada doesn't necessarily have the expertise to be able to do that alone. And that's no disrespect to the many hardworking public servants that I know are scattered across the country trying their absolute hardest. But it is actually with the expertise of Dr. Blackstock and the AFN and the other parties that we will get to a place where we are able to achieve those goals without re-traumatizing individuals and in a way that is appropriate and designed to end this discrimination once and for all.
But that takes longer, right? Like what you're proposing could just...
Well, no, we've actually agreed that we will. We've always, from the get-go, said that any of these cases, to the extent we have any respectful disagreements with, we're prepared to expedite the decisions on them, and that's something that has actually moved fast in this case, and will continue on that path. But I don't want to presume the outcome. Again, this is highly complex, but there's a very simple scenario where you could very well have one child that's covered by the compensation order, a child that, because of one day prior being in care, is not compensated by the order. could presumably get less. That same child who was compensated by the order is only up to 40,000 and then has to go through a class. So that's why we need everyone at the table, David, is because we have to have that discussion as to how this articulation of a framework would do. From the date in 2019 when the Prime Minister stood up and said there's been discrimination, we're going to compensate these children, 2 class actions were filed. At the same time, I made sure that Dr. Gideon, who's been working within our department with Dr. Blackstock at the negotiation table, along with lawyers, was sitting down coming up with a framework that is close to 200 pages so we can proceed to compensate children in an expedited fashion and not re-traumatize them. We know there's documented evidence of this compensation process re-traumatizing people, and we are dealing with a younger class of people. So if you're asking the same child to go through 3 processes to get compensated, there's a real risk there. And so those are all discussions that we're going to have. We've had them to some extent before, but now we can come together with one mind, plus with long-term reform, which is so key, so that we're not back here in 5 years trying to continue to fix a broken system. It's important, it's significant, it represents significant investments on behalf of the government of Canada, but we're being mature and we're going to sit around the table and hash this out.
David, in addition to what Mark said, just also in terms of fairness and timeliness, so we feel that by doing this we can get it done faster, but we can also achieve a measure of finality to this. If you leave other pieces, they keep going, they keep going, they keep going. We think by getting everybody around the table, by putting a significant offer at the table, by addressing everyone touched by this, and by addressing how we plan to fix it so that we're not here again, we achieve a measure of finality. And that's important for both Indigenous and non-Indigenous peoples, because we need to move on the reconciliation process. We need to move forward. And this is a way to get everybody moving forward. And I think the fact that everybody has agreed to try this is significant.
Thank you. That ends our press conference. Have a nice evening.
Thank you. Merci.